I call the Honourable Member Jan Logan.
Thank you, Mr. Chair. Sorry, colleague. So, I'd like to speak a little bit more around the non-contact orders and the we do absolutely support the lowering of the level for to the 2 years as opposed to the 5 as this was introduced. And as I spoke in the earlier stage a little bit about some of the challenges that we have to make this more viable or useful for the majority of victims of sexual violence in New Zealand, I'd like to just briefly go through some of the changes that were recommended in the Law Commission that would process so far that would help make that possible. So in the Law Commission's report and what we've had so far from it, there were three proposals that received almost universal support, and that was child protection orders, a specialist sexual violence court at the point post-conviction, and alternative processes for sexual offence cases, which the Honourable Phil Goff has just been talking around restorative justice processes. And while the Minister mentioned earlier about some of the differences from the time when he was working as a police officer, when the offence rate was very low for sexual violence, I personally still remember the public discussion we had at the time we raised the sentencing for rape, and it was a very controversial decision, and one that I actually think needs reviewing, because it is acting, and we hear this back from people, that it is acting as a disincentive for people entering the justice system, because it is such a high level that people are going to be put away for, that it is a disincentive to using the processes. And also we do need to acknowledge that the majority of offenders are known to their victims. They are family friends. And the thought of sending somebody away to jail for a very long time is a disincentive to actually holding that person accountable and getting the response that most victims and survivors want, which is having an acknowledgement of the crime and knowing that that person is not going to offend again and that others will be safe. And sadly, we don't have that system yet. This bill only deals with those very rare cases where that conviction has happened and does put that measure in place, but not enough. I would like to also just talk a little bit about how this may apply in a domestic violence situation, and also acknowledge the extending of this out to what people otherwise are referring to as surrogates, which is usually the harassment of a victim by family or friends of the perpetrator. And that is a very real dynamic in domestic violence in this country and everywhere. And when I was working in Women's Refuge, that was quite a common experience, where we would be with a woman and she would be hiding in public because her abuser had friends and family out looking for her. So it wasn't possible for her to feel safe walking in a public space because she never knew where they might be and who she actually even needed to be looking out for. So it is very important that there is a provision in this bill to protect victims from the harassment from those other people when there is a concerted effort to harass them. But we also, again, need to be looking at how our court systems are working to support this kind of measure of protection, because the reality is that a lot of our family court decisions at the moment are working against this level of protection, that we don't have a system in place that understands and ensures custody decisions, in particular through the family court, that the people involved in making those decisions actually understand domestic violence. I was at a seminar last week organised by the Family Violence Clearinghouse, and they brought out a US expert, Professor or Dr. Bob Geffner, who is an expert in custody decisions where there are accusations of child abuse or domestic violence, and he's well over all of the literature and knows the best of Mr. Chair. Mr. Chair.
Honourable Member Jan Logie.
Thank you, Mr. Chair. And it was very disturbing to hear that in New Zealand we have been getting people who have been thoroughly discredited in the US and are not allowed to give evidence in the courts in the US, and they have been coming out to New Zealand and training people in our courts on matters relating to the supposed best interests of the children and custody decisions through our family court. And we have no system of oversight to ensure that the people, the counsel for the child, the lawyers or the mediators in our systems actually understand domestic violence. So decisions are being made that are putting our children at risk and are taking children from situations of domestic violence where their mother usually has left the relationship. It is giving joint custody arrangements and putting that woman and child at risk because they're having to negotiate shared custody in the context of a violent relationship. Now, as a country, we can put things like this in place, but if we don't address the absolute fundamentals that underpin it all, we're not going to get the result that I believe, I'm sure everyone in this House wants, which is enabling women to get out of violent relationships, for offenders to get the support and treatment they need to be able to change their beliefs and their attitudes and their behaviours, to be able to give children back to healthy parents and have a hope for themselves of a healthy life free of violence and being able to live up to their own potential. Sadly, we do not have those systems in place as a country at the moment, and this bill becomes just so piecemeal in that context.
I call the Honourable Member Carol Beaumont.
Thank you very much, Mr. Chair.